Government has tabled Bill C-2, otherwise known as the Strong Borders Act. Much of it is about the border and the movement of goods and people across that border, but critics say the bill also includes legislation that could compromise the online privacy of Canadians. Michael Geist is the Canada Research Chair in Internet and E-commerce Law at the University of Ottawa. He joins us on the line. Good morning.
Oh, good morning.
So what are the biggest privacy concerns raised by Bill C-2?
Oh, there's some really significant ones. This is the return for people that may recall it of lawful access, the rules around which law enforcement is able to gain warrantless access to subscriber, or it turns out just anybody's information. And this dates back now a couple of decades. We saw the Harper government try to bring this in, and a lot of it stopped for a better part of about a decade after the Supreme Court of Canada said, hold on, Canadians have a reasonable expectation of privacy in their subscriber information. The government is now bringing back rules that would give law enforcement warrantless access to certain information. They can make what's known as an information demand to providers. And what I have to say, what is shocking about this is it's not just the internet, it's not just telecom companies. It quite literally is any service provider, a physician, a lawyer, could be your gardener, for all I know, who could be targeted with one of these information demands.
Because I read one report that said that also gives the law enforcement officials the power to open your mail.
It does. There's a separate element in there that's not lawful access that speaks to the power of opening the mail. Mm-hmm. Government argues that there is already that power with courier companies and that they need the similar kind of power within the context of the mail. Right. And while I think that's certainly attracted some attention, to be sure, it's the lawful access stuff that I think is in many ways the most problematic, partly because I think it's unconstitutional. It runs counter to what the Supreme Court of Canada has consistently ruled about people's privacy, but also just because of how expansive it is. Unlike some of the earlier proposals that, as you mentioned off the top, might target information about what people might be doing online or who they might be communicating with via telephone, the government now has expanded this quite literally to anyone who provides a service in Canada. Stayed at a hotel last night, law enforcement go to the hotel and say, hey, was this person a client? When did they check in? When did they check out?
Wow.
What other information do you have about them? All without a warrant.
Right. Okay. So I guess that's the next question I was going to ask you, as you keep saying warrantless. Is that the big change? I mean, because now presumably law enforcement can do those kinds of things, but they need permission first.
That's exactly right. I mean, we need court oversight for those sorts of things. It might be appropriate to go to that hotel, or to go to a physician or an accountant, or to a telecom company and obtain that information. In fact, in the context of telecom companies, they've provided warrants seeking information about subscribers hundreds of thousands of times every year, even with the changes that the Supreme Court of Canada made. So there is a system already in place for this. But what is essential, as you point out, is that there is some court oversight. What the government's proposing here is that for certain kinds of information, they can go to these entities and say, we demand you provide this information, and there is no court oversight associated with it.
Of course, I mean, there are lots of critics who are saying this violates our civil liberties, but there are lots of proponents, like the Canadian Association of Chiefs of Police. They say Canada, first of all, we lag behind our allies, and they say and that the criminals are way ahead of us. And so they say, we need the police chiefs need the bare minimum. They're online predators, child pornography, and that got trotted out. You mentioned when the Harper government tried to pass this, those reasons also got trotted out then. I mean, how valid is that?
Yeah, no, I'm shocked to hear that law enforcement says they would like more powers, using the same arguments that they have used for, as you point out, decades. And the rationale often comes back to the same kinds of things about terrorism. Now they actually are citing fentanyl as one of the reasons for this. And yet, 10 years after the Supreme Court of Canada ruled that basically you needed to come back with a warrant, and so it stopped this warrantless access, we have had a system in place that if you take a look at the transparency reports from companies like Bell and Rogers, you find they are receiving hundreds of thousands of these warrants every year, and they're responding to them, and there's the court oversight that we need. We could talk about creating a new kind of warrant, some new kind of oversight if there is a problem in terms of how expeditious they're able to obtain this. But the idea that we would simply toss aside people's privacy, I don't think strikes a balance that many Canadians would like. And frankly, it doesn't strike the balance that I think our Constitution calls for.
And is it true that other allies have made it more accessible for lawful access?
I think there's a range of rules that you find when you start looking at what different countries have done. I'm not aware of any country that is proposing something as broad as what we see in Bill C2. This notion, not just of telecom companies, but of any service provider. Department officials were asked just yesterday at a briefing, does this really include your psychotherapist and your car rental company? And the answer was yes.
Wow. All right. But it does seem to, and as you mentioned, and we've been talking about, this is something that has tried and failed to pass before. But now we have President Trump. And now we have this whole, you guys need to strengthen your border. And it was kind of slid under. I mean, certainly didn't make the headlines right away, the Strong Borders Act. How open do you think the government's been about it? And how likely do you think it is to pass?
Yeah, well, the two questions there. I mean, I think they haven't been open about it. It's pretty clear that, they've tried to slide this by, I think, people. They didn't talk about any of these issues when they first introduced the bill. It was, as you say, focused on the border. This has nothing to do with the border. I mean, this is an attempt to create an omnibus bill where they're slipping in all this additional stuff, both in the hope that MPs, members of parliament, are simply going to pass the legislation because they may support other provisions there. And I think hoping that people wouldn't pay much attention. It's quite literally buried at the very end of this legislation. Mm-hmm. And so, as much as many criticized the Harper government, and I was one of them when they were moving ahead with lawful access, at least it was its own bill that could be debated on the merits and people could understand the implications.
Right.
In this instance, they're packaging it together with a whole bunch of things that have nothing to do with this. I think largely in the hope that people won't be paying much attention.
And you mentioned some challenges that went all the way to the Supreme Court, and we've seen this in the States. Is it possible, if it is passed, it could be quashed by the Supreme Court for the reasons you stated?
Yeah, I think it's a certainty that it's going to be challenged. I mean, there's simply no doubt, given what the court has ruled, not just 10 years ago, even just last year, where they doubled down and expanded on their commitment to the reasonable expectation of privacy of Canadians. This, I think, really does run counter to what the court has been articulating for some time. And, if this passes in its current form, it's quite clear that someone will challenge it on similar grounds.
Mm. All right. Well, thanks so much for your time this morning. I appreciate it.
Oh, my pleasure. Thanks for having me.
Bye-bye. That's Michael Geist. He's a Canada Research Chair in Internet and E-commerce Law at the University of Ottawa.